The matter to come before the court this morning is Derrick Martin King versus Terri L. Davis et al. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you let me know when you get started, I can keep track of the time and let you know when you're getting close to any of that rebuttal time that you may want to reserve. Just some housekeeping matters. I don't think it's all that relevant to this case, but we never want to use the names of victims or children in oral argument. We are live on YouTube. If you would also mute your microphone when you are not speaking so we can avoid some background noise. It's also my understanding that although there are two appellees that you have been informed that you need to share that 15 minutes and you've taken care of that on your own. You don't need to let me know how you're doing it. As we proceed through, I'm just gonna let you guys take care of that. It gets a little difficult on video to take care of, for me to take care of it for you. We've read the briefs. We're ready to proceed when you are, Mr. King.
Yes, ma'am. Judge Henshaw, Judge Callahan, and Judge Sutton. I will begin this argument by reserving the maximum 5 minutes for rebuttal. There are 5 issues that are before this court. 1, whether the trial court erred by failing to hold an initial pretrial hearing. 2, whether the trial court erred by refusing to allow the parties to conduct discovery. 3, whether the trial court erred by granting the motion to strike the amended complaint. 4, whether the trial court erred by granting the quote unquote supplemental end quote motion to dismiss. And 5, whether the trial court erred in refusing to recuse itself from the case. As this court is well aware, this is the 3rd time that the parties have been before this court in 2 separate cases. This court reversed the trial court's initial dismissal order. That was a clear signal that the trial court should have held a pretrial hearing under Civil Rule 16 and the local rules of the Summit County Court of Common Pleas. The same legal theory applies to the trial court's blatant refusal to allow the parties to conduct discovery. By refusing to allow discovery or hold a pretrial hearing, the trial court committed clear reversible error, and thus the judgment must be reversed as a matter of law. With regard to the trial court's dismissal to strike the amended complaint, the trial court ignored the clear precedent set by the Ohio Supreme Court and this court. In King v. Semi Valley Sound, LLC, which was 2011, Ohio 3567, the pro se plaintiff filed an amended complaint after the defendants filed a motion to dismiss. This court stated at paragraph 6 that, quote, there seems to be a confusion in this matter regarding whether Mr. King was permitted to amend his complaint. According to Mr. King, his amended complaint stated the same grounds for relief in the original complaint, but dismissed Miss Oakley and Miss Sanchez, but added the Albrights and several unknown John and Jane Does as defendants. He had argued that he was permitted to amend under Rule 15A of the Ohio Rules of Civil Procedure because that rule allowed a party to amend its pleading once as a matter of course of any time before a responsive pleading is served. Under Civil Rule 7A, pleadings include only complaints, answers, and replies. As the named defendants in this case never filed answers, but merely moved to dismiss under Rule 12B6, Mr. King did not require leave of the court to amend his complaint, and that's citing State Ex Rel. Hansen versus Guernsey County Board of Commissioners. Thus, the amended complaint was only viable pleading at the time the trial court ruled on the defendant's motion to dismiss. Now, in this case, the doctrine of stare decisis is a doctrine applying to future cases whether the facts of a subsequent case are substantially the same as a former case. Black's Law Dictionary. The Supreme Court of Ohio stated in City of Rocky River versus State Employment Relations Board that, quote, stare decisis is, of course, shorthand for stare decisis et non quieta mueve, stand by the past decisions and do not disturb settled things. Black's Law Dictionary. The heritage of the law is built like a wall, brick by brick. The spirit of the Anglo-Saxon law is as part of the impact as they come down through the years. Each case, as it's decided, supplies another brick for the wall and gives us the taught tradition of the law. This tends to provide the stability necessary for an organized society to deal with its everyday affairs. Uniformly and continuity in the law are necessary for us to deal with our daily pursuits. We need to preserve the integrity of contractual agreements, wills, conveyances of property, and our dealings in the commercial marketplace. The application of the principles of tort cannot be an ever-changing concept. What is negligence in the morning must also be negligence in the afternoon. To permit such standards to be in a continuous state of flux would invite havoc. The doctrine of stare decisis provides that solid rocks upon which men and women can build and arrange their affairs with confidence. The doctrine serves to remove the capricious element from the law and lends the stability into society. Stare decisis is a strong tie in which our future has had with our past, end quote. Since this court's decision in King v. Semi Valley Sound was never overturned, it is still binding precedent in the 9th District. With regards to the trial court's decision to grant the supplemental motion to dismiss, this was clear error. Opposing counsel filed a motion to dismiss, and it was ruled upon by this court. Accordingly, there was no motion to dismiss the complaint, and the trial court's decision must be reversed. Also, the trial court cited Daltrey v. Wallace in finding that there is no constitutional right to welfare benefits. However, the trial court did not properly analyze the law in reaching this erroneous decision. For example, in the case of LTV and New Jersey Department of Human Services, the New Jersey Supreme Court held that regulation terminating temporary rental assistance benefits after 1 year for recipients who were compliant with their obligations under regulatory program conflicted with the purpose of the general assistance to provide temporary shelter for those in need. This goes against the fundamental right to safety and is found in various state constitutions around the country. On a more controversial issue, the New Jersey Supreme Court held in Right to Choose v. Byrne that a woman's right to choose and protect her health by terminating pregnancy outweighed the state's asserted interest in protecting potential life at the expense of women's health, and thus the statute restricting Medicaid funding to abortions necessary to save not the life of the mother violated the New Jersey Constitution. The issue of general assistance benefits for rental assistance and the right to obtain abortion at public expense are more controversial than state disability financial assistance benefits. Yet in these cases, the court upheld the payment of those benefits. This court must also do the same. In 1941, President Franklin Delano Roosevelt the United States commitment towards promoting the safeguards, basics, human rights in his famous 4 freedom speech. The third freedom was freedom from want. During his presidency, Roosevelt commented on the duty of Americans to provide for everyone's need. I see 1/3, quote, I see 1/3 of a nation ill-housed, ill-clad, ill-nourished. The test of our progress is not whether we add to the abundance of those who we have much. It is whether we provide enough of those who have too little, end quote. Ohio's Constitution of right of safety is consistent with prior versions of the Ohio Constitution. For example, the Ohio Constitution of 1802 made explicit that even a pauper's children can attend public schools. Ohio Constitution of 1802, Article 8, Sections 15 and 25. In addition, the state amended its constitution in 1990 to authorize the legislature to provide subsidized housing for low-income individuals. Ohio Constitution, Article 8, Section 16. Quote,
Mr. King?
yes.
Mr. King, you're just now reaching your 5 minutes of rebuttal time. You may proceed or you may reserve.
Okay. Well, I'm going to conclude here momentarily, but in conclusion, I will quote legal scholar Dan Braverman, who said, a state's traditions can also serve as the basis for independent interpretation of state constitutional provisions. And with that, I'm going to reserve my remaining time.
Thank you. Counsel for the appellees.
Good morning, Your Honor.
Morning.
Teresa Dirasammer on behalf of the Ohio Department of Job and Family Services. May it please the court, I will be presenting argument on behalf of the appellees. This court should affirm the lower court's dismissal of the complaint for failure to state a claim. Mr. King has raised 5 assignments of error, none of which should be accepted by this court. This argument will focus primarily on the 4th assignment of error that concerns the dismissal of the complaint. The lower court did not err in granting the motions to dismiss and in dismissing the complaint. This court, in a previous decision, had remanded the case back to the lower court. The parties had previously moved to dismiss. The lower court granted those motions. Mr. King appealed, and this court reversed and remanded, finding that the lower court had applied an incorrect standard, specifically that the lower court had not applied the correct standard to dismissal of a complaint for declaratory judgment. The court remanded for further proceedings consistent with its decision, and the lower court then reconsidered the motions to dismiss. It considered a supplemental motion to dismiss that the department filed and that Mr. King responded to. It applied the correct standard and it then dismissed the complaint. And that decision was not erroneous. Mr. King's really only argument is that there wasn't a motion to dismiss pending before the court. He doesn't argue that the lower court applied the incorrect standard or that it applied the correct standard improperly. He simply says that there wasn't a motion to dismiss pending, and that is not the case. As an analogous situation, our briefs directed this court to a previous decision from the 9th District where the Circuit Solutions cases, where the 9th District had acted similarly. It reversed and remanded, directing the lower court to take further action consistent with its decision. And in those cases, in that case, the lower court in the Circuit Solutions case then followed the 9th District's instructions, reconsidered the matter, applied the correct standard, and then redismissed the action. And the Ninth District characterized its previous remand as an instruction that the lower court apply the correct burden of proof. The Ninth District stated that we remanded the matter for the trial court to apply the correct standard. And that was based on the language in the decision that the case was remanded for further proceedings consistent with that decision. And that's the same thing that happened here. The Ninth District previously remanded for further action consistent with its decision, which was an instruction to the lower court to reconsider the motions to dismiss and apply the correct standard. That's also how the lower court in this case characterized the instruction in its decision. It noted it was instructed by this court to apply the correct standard to the motions to dismiss. So there was a motion to dismiss properly pending before the court, and the lower court correctly found that there was no justiciable issue or controversy, and it dismissed the complaint for declaratory judgment on that basis.
Counsel, regarding the motion or motions to dismiss, what differences, if any, were there between the original motion and then the supplemental motion?
The supplemental motion focused on the fact that there wasn't a justiciable issue or controversy.
So the supplemental motion was a response to this court's reversal, is that?
Yes, it was, Your Honor.
All right,
yes.
Go ahead.
So it incorporated this court's guidance on the correct standard to use and presented arguments regarding the fact that there was no justiciable issue or controversy. And as I said, Mr. King then responded to that supplement, and the court considered it along with the other motions to dismiss in dismissing the complaint and in applying the proper standard. As I said, the lower court went through the issues and found that they didn't present any justiciable issue or controversy. The lower court found that the claims and the complaint relied on conclusory allegations and found that when a plaintiff is suing for a claimed constitutional violation and they fail to allege a constitutionally protected interest, there is no justiciable issue or controversy. And the court then went through the plaintiff's claims, found that there were no constitutionally protected interests that were properly alleged in the complaint, and it concluded that there was no justiciable issue or controversy. And the substance of that decision really has not been challenged by Mr. King in this appeal. Again, his main focus is just that there wasn't a motion to dismiss pending before the court. His whole argument section under this assignment of error is just a paragraph, and it doesn't contain any citations to law. It simply says that there wasn't a motion to dismiss pending before the court. So that, the appellant has the burden on an appeal, including the burden to demonstrate his assigned error through an argument that is supported by citations to legal authority and facts in the record. And citations to record in a statement of facts isn't sufficient. That doesn't comply with the appellate rules. The argument section itself has to have the complete argument. And in this case, that burden wasn't met, both because there aren't any citations in Mr. King's argument section under this assignment of error, but also just more generally speaking, the lower court didn't err when it dismissed the complaint because there was a motion to dismiss pending before it following the remand from this court, and because it did apply the correct standard when it dismissed the complaint the second time.
Counsel, I have another question for you. There was a related but unrelated case that also went to the Ninth District, and that was the administrative appeal that went to common pleas and then to our court. What role, if any at all, does our ruling in that case play in this case, or what the trial court found in this case?
Our position, those two cases were filed at similar times. This complaint may have predated the appeal, but our position from the beginning was that that administrative appeal really divested the lower court of jurisdiction due to the nature of this case and the Disability Financial Assistance Program. Challenges to actions regarding that program are committed to a special statutory proceeding, in this case, an administrative appeal through revised code section 510135. The lower court, in this case, rejected that argument and found that it did have jurisdiction, but there were very similar arguments raised in that case versus this case. Mr. King was still challenging the agency's decision and raised constitutional arguments in that matter, specifically regarding due process, equal protection, and the right to safety. And the court in that administrative appeal affirmed the agency's actions. The standard is different. In an administrative appeal, the court has to find that the agency's action is supported by reliable, probative, and substantial evidence and is in accordance with law. But the findings regarding the constitutional violations would speak to whether the action was in accordance with law. So I would say that previous action did already rule on some of the specific issues that Mr. King had raised to the lower court, but with the issues being so narrow in this appeal, he really doesn't make any assignments of error regarding the merits or the substance of the lower court's decision. So I'm not sure that the administrative appeal really resolves the specific issues in this appeal.
Thank you.
I do also want to respond to his arguments regarding the amended complaint and it being struck when the amended complaint was struck because it was filed without leave. Mr. King relies on the Semi Valley case, which was decided prior to an amendment to Civil Rule 15. At the time of the Semi Valley case, Mr. King is correct when he said that a complaint could be amended anytime prior to the filing of a responsive pleading. But since Semi Valley, that rule was amended and it limits now amended complaints to within 28 days of the filing of a responsive pleading or a motion to dismiss. So it's not the case that Semi Valley has been overturned by another court action, but it's been superseded by an amendment to Civil Rule 15. Now Civil Rule 15 requires leave if more than 28 days have passed since motions to dismiss were filed. And in this case, the original motions to dismiss were filed in 2017. The supplemental motion to dismiss was filed in 2018. The case was then stayed beginning in late November of 2018 for over a year. And then the amended complaint was filed in January of 2020. So well more than 28 days had passed from the filing of even the supplemental motion to dismiss, meaning that leave was required before a complaint could be amended. Leave was not sought, and the lower court didn't err in striking the amended complaint as a result. To briefly touch on the remaining assignments of error, first specifically regarding the pretrial hearing and the order staying discovery, trial courts have broad discretion to control their dockets, including pretrial and discovery matters. The lower court was well within its discretion to decide that a pretrial conference wasn't necessary, especially with the motions to dismiss pending. And the court also acted well within its discretion when staying discovery pending dispositive motions. There's ample case law saying that a lower court acts within its discretion when staying discovery pending resolution of a motion to dismiss. And that's what happened in this case. There were motions to dismiss pending, and the lower court didn't find that discovery was necessary under that circumstances. So the lower court acted properly when taking those actions. And then the final assignment of error is in regard to the judge failing to recuse herself upon Mr. King's request. As we Explained in our brief, appellate courts are without jurisdiction to review the disqualification of a judge, and specifically a judge's ruling on a motion for recusal. Instead, the procedure is to go through the exclusive jurisdiction of the Chief Justice of the Supreme Court through a more of a disciplinary procedure. There's a statutory procedure to follow to review recusals or denials of recusals of judges, but this court lacks the jurisdiction to consider a motion to recuse a judge. There were a couple of cases that Mr. King relied upon in his reply brief. He relies on cases from the 1st District, Loudermilk, that cited to the case of Lamar. Both of those cases were in the criminal context and discussed a criminal defendant's constitutional right to a fair trial before an impartial judge. It is not the same issue as a motion to recuse. Ohio Supreme Court precedent is clear that motions to recuse are not reviewable by appellate courts and have to instead go through the Ohio Supreme Court. If there are no further questions, we would ask this court to affirm.
Thank you, counsel. Mr. King, you have just under 5 minutes remaining for your rebuttal, and we're ready when you are.
Okay, yes, I'm going to answer Judge Callahan's question. In regards to the administrative appeal, the administrative appeal was filed in September 2007. This case was filed in August of 2007. So that, yeah, it predated that. And it was also my argument at that time that this case took precedence, as well as, the discovery and everything else should have occurred then. It's not, I tried to attempted to get the discovery in the administrative appeal, but that the trial court in that case rejected that. Now, regards to civil rule 15, notice that opposing counsel did not cite any case that specifically overruled any of the prior precedents. She cited no decisions in regards to that. Now, in regards to the discovery, the final point that she brought up in regard to the recusal, I cited in my brief is a statement from Judge Maureen O'Connor that stated that a motion to recuse a judge does not necessarily have to be filed. Affidavit of disqualification does not necessarily have to be filed with the Supreme Court, but a motion to recuse can be filed with the trial court, and one was. And that's why this court must resolve the merits of that decision. And with that, I'm going to close.
Thank you, everyone, for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on our website and the Ohio Supreme Court website. I do appreciate everyone agreeing to be present today via video oral argument, and our next video oral argument will be Thursday, February 18th. Thanks again.